ಆದೇಶ ಆಗಿದೆ, ಇದು ಮಾಡಿಲ್ಲ.
Passed over matters. Number 13, Chetan Munnoli.
Petitioner. So I filed the amended cost title in the registry.
And counsel for the petitioner submits that the amended cost title has been filed in the registry. Registry is direct put up the same.
Please, my lords.
And you are a purchaser?
I'm the purchaser, my lords. In this case, my lords, Assistant Commissioner has initiated so much of proceedings. After, my lords, many years. In the year 1995, my lords, I purchased this property.
The validity is decided, we can't pass orders. We'll decide the validity and then do it. Validity is on 9th matter ಇದೆ.
It was yesterday, my lords. It was listed yesterday for orders.
ಯಾವುದು?
Validity matter.
ನಮ್ಮ ಮುಂದೆನೇ ಇರೋದು, ಹೆಂಗ್ ಲಿಸ್ಟ್ ಮಾಡ್ತೀವಿ? 9th further hearing ಇದೆ.
Please.
So you can be here to assist in that matter also.
Please.
9th released on 30th January.
Please.
Twenty-one, Pawan Doddatti.
Fifth respondent here in lots disputing the measurements. Lots in respect of survey number 124/2, 3 and 4. Lots challenged the ME number lots 444 dated lots 23/5/1966. Nearly after 50 years lots before the assistant commissioner. As per annexure B lots. And lots the assistant commissioner.
You had purchased in 69 and the entry was made in 69.
Please. I'm sorry.
69 your predecessor had purchased it.
Please. As per annexure B lots, there was nearly 50 years delay, and without giving opportunity for us to file objections, lots the appeal was allowed, and the same was challenged before the DC, first respondent. The first respondent has dismissed the revision, and the same is challenged before this honorable court, and lots there is status quo order passed. And such being the case, lots there was another appeal filed by the present petitioners in view of the dismissal of a suit which was filed by the fifth respondent. Lots that appeal was allowed. And lots there was a revision filed against the said appeal by the fifth respondent. Lots fifth respondent has allowed the revision, saying lots his earlier order as per annexure C has attained finality. In fact, I have challenged it, and there is an interim order in the said matter as per annexure D. That was the very lots
reasoning. Accepts notice for respond number 1 to 3. Issue emergent notice to respond number 4 to 6. Returnable by 13th February. The
sought for stay of them lots.
Proceedings pursuant to order dated 11/7/24 in RP number 42 of 2023 passed by the first respondent is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 8th January, failing which the interim order would stand automatically vacated.
Please.
Again, part of the order dictate agide. ಬೆಳಿಗ್ಗೆ part order dictate agide. ನಿಮಗೇನ ಅದಾದ್ಮೇಲೆ
Appellate.
Accepting reasons stated in support of IA 1 of 24, production certified copy of annexure G is dispensed with.
Please.
23, Praveen Kumar G. Kulkarni. Praveen Kumar.
ಬೆಳಗಿನ ಬಂದಿಲ್ಲ ಅಲ್ಲ. None appears for the petitioner, though called twice. Court all moved. Yeah, Praveen Kumar. 23, court all moved ಇದೆಲ್ಲ. ಪ್ರವೀಣ್ ಕುಮಾರ್ ಕುಲಕರ್ಣಿ ಸರಿ ಇದೆಯಾ ಇದು? ಇಲ್ಲೇನಾದ್ರು ಇದ್ರೆ ಪಾಸ್ ಓವರ್.
Thirty-four, Ravi Kumar Gokakar.
S. Patil. Elsabil. 34.
File is missing from the office.
File is missing. 2005 matter,
Please, your lordship.
when will it be found?
Just my lordship, make necessary.
At counsel for respond number 3, Viresh B. Patil.
He is no more. I think he was practicing it. I think he left. He is no more.
ಯಾರು appear ಆಗ್ತಾರೆ?
No more. Huh? Vivesh B. Patil ಅಲ್ಲಿದ್ರು.
Viresh B. Patil. ಬಹಳ ದಿನ ಆಯ್ತು.
He was practicing at shifted to Kalburgi and
ಯಾರು appear ಆಗ್ತಾರೆ ಅವ್ರಿಗೆ?
yes Patil because R3
Viresh B. Patilದು ನೀವೇನಾ?
ಇಲ್ಲ ಲೋಡ್ಸ್ R3 ಗೆ ನಾವು ನೋಟಿಸ್ ಮತ್ತೆ
ಅರೆ,
ವೀರೇಶ್
ಆ
ಪಾಟೀಲ್
3 to 10 ಗೆ ವೀರೇಶ್ ಪಾಟೀಲ್ ಅಪಿಯರ್ ಆಗ್ತಾ ಇತ್ತು.
ಮತ್ತೆ 3 ನಾವು ವಕಾಲತ್
but
4 to 10 ಏನ್ ಮಾಡೋದು?
court notice ಹೋಗುತ್ತೆ.
ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿ ವಕಾಲತ್ ಹಾಕಿ.
ಪ್ಲೀಸ್ ಯುವರ್ ಲೋಡ್ಶಿಪ್.
ಕೋರ್ಟ್ ನೋಟಿಸ್ 3 ತಿಂಗಳಾಗತ್ತೆ. 2005 ಮ್ಯಾಟರ್.
ಪ್ಲೀಸ್ ಯುವರ್ ಲೋಡ್ಶಿಪ್.
It stated that Sri Viresh B. Patil, that counsel who had appeared for respond number 3 to 10 has expired. Sri A.S. Patil has entered appearance for respond number 3. He seeks for and is granted a week's time to obtain instruction as to whether he will be appearing for respond number 4 to 10. Relist on 22nd January. As told, get instruction. If you get wakalatnama, file it.
Please ಯುವರ್ ಲೋಡ್ಶಿಪ್. 35 PM Shilvan.
ನಿಮ್ಮನ್ನೇ ಕರ್ಕೊಂಡು ಬಂದ್ರೆ we'll dismiss it, Michelle. 2011 is when it was abated. ಅವ್ರ ಹೆಸರು ಬೇಡ ಅಂತ.
Property rights are involved.
It may be, but 2011, we are in 2000,
Delay is there, I do consider.
we are in 2024. Your application is filed in 2024.
May I request one thing?
Abated on 14/3/2011.
Illa, the property rights are involved, you also can allow the applications, you also can hear it on merits.
This is
With
complete
cost,
negligence. What is the sanctity of?
Illa,
after
she is a
14
lady,
years?
my lord, she died and nobody was there. Some relatives have.
This is a petition of 2007 when respond
Yeah, I
number
do
4
concede.
and 7 expired on 14/3/2011. Respond number 11 expired on 9/11/2011. 1/3/2018, 3, 9 and 13 had expired and dismissed as abated.
Illa, I do consider.
So 3, 4, 7, 9, 11 and 13.
No, sir,
ಅದು
I will
notice
claim.
ಮಾಡಿ, this was dismissed on 19th March 2018. Not a case to do it.
Illa, I do.
Condition of delay of 1571 days in filing the recalling application. The above petition had been dismissed on account of steps not having been taken in respect of deceased respondent by order dated 19th March 2018. A perusal of the said order would indicate that by way of order dated 14/3/2011, the petition had been dismissed as abated as against respondent number 4 and 7. By order dated 9/11/2011, the petition stood abated as against respondent number 11. By order dated 1/3/2018, the petition stood abated as against respondent number 3, 9 and 13. As such, it is clear that the petition as on 1/3/2018 stood abated against respondent number 3, 4, 7, 9, 11 and 13. It is noticing the above and noticing that the petitioner was a rival tenant. No steps having been taken over last 7 years. The petition was dismissed by way of the order dated 19th March 2018. The application for recalling the said order has been filed in the year 2024, seeking for condonation of delay of 1571 days. In fact, along with the said application, several other applications have been filed to bring the legal representative of deceased respondent. In effect, the said applications trace back to the year 2011. After a period of 13 years, I am of the considered, more than 13 years, I am of the considered opinion that the said applications cannot be considered. The reasons stated in the affidavits accompanying the various applications are therefore rejected. IA 1 of 24 and 2 of 24. IA 1 of 24 seeking for condemnation stands dismissed. Consequently, IA 2 of 24 filed for recalling the order dated 19/3/2018 stands dismissed. Consequently, IA 3, 4, 5,
3 to 11.
6, 7, 8, 9, 10, 11
3 to 11.
of 2024 stand dismissed.
41, PV Somapur.
We are for the petitioner number 2 in this matter, my lords.
Vijay Kumar.
Balgir Mutt. Please.
My lord,
Vijay Kumar
PDO.
Balgirmat is directed to accept notice for
In pleading up
Respond number
respond
four.
number 4.
respond number 4.
IA 1 of 2022 has to be allowed, my lord.
Allow.
Allowed.
Allow ಆಗಿದೆ.
1 of 22 ಅಲೋ ಆಗಿಲ್ವಾ?
Allow ಆಗಿದೆ my lords. Allow ಆಗಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ. Allow ಆಗಿದೆ.
ಬರೀ ನೋಟಿಸ್ ಆಯ್ತಾ ಅಲೋ ಆಯ್ತಾ?
Allow ಹೆಂಗಾಯ್ತು?
ಇಲ್ಲ. ಇರೂರ್ ಸಾಹೇಬರು ಆರ್ಡರ್ ಮಾಡಿದ್ರು.
Without passing the notice on the pleading application.
ಇರೂರ್ ಸಾಹೇಬ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರು. ಇರೂರ್ ಸಾಹೇಬ್ ಆರ್ಡರ್ ಚೆಕ್ ಮಾಡಿದ್ದೀನಿ.
Application ಹೆಂಗಲ್ಲ?
ಅಲೋ ಆಗಿದೆ 17/6/22
ಪ್ಲೀಸ್.
without notice. Okay, so and so accepts notice for respond number 4. Counsel for the petitioner is directed to furnish 2 sets of the petition
Sir,
along with annexes on the said counsel, who in turn seeks for 2 weeks' time to obtain instruction, make his submission.
Please.
Released on 30th January.
Please, your lordship, oblige.
ಇನ್ಮೇಲೆ ಇಲ್ಲಿ ಅಪಿಯರ್ ಆದ petitioner's duty
Please.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಅಂತ.
Please, your lordship.
Much of it has been uploaded on the website.
Please, your lordship.
ಎಲ್ಲಿದೆ ಗೊತ್ತಾ?
ಅದು ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಒಂದು ಲಿಸ್ಟ್ ಇದು ಮಾಡಿದ್ರಲ್ಲ.
ಈ ಸರ್ವಿಸಸ್ ಕೆಳಗೆ
ಪ್ಲೀಸ್.
ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಮುನ್ಸಿಪಾಲಿಟಿ, ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಪಂಚಾಯತ್ ಎಲ್ಲ ಇದೆ.
Please, your
You
lordship.
have a look at it and say who is the person here. You will serve it.
Please, your lordship.
ಅಲ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಫೈಂಡ್ ಔಟ್ ಮಾಡಿ ಯಾರು ಅಂತ ಹೇಳಿ ಆ ಲಿಸ್ಟ್ ಅಪ್ಡೇಟ್ ಮಾಡೋಣ ಅಂತ.
Please, your lordship.
ಇವ್ರಿಗೆ ಹೇಳೋಣ ಅಂತ ಅಪ್ಡೇಟ್ ಮಾಡಿಸಿ.
Oblige.
51, Venkatesh Harvi.
Challenging my lords, that the order passed by the assistant commissioner, my lords, that's regarding no motion confidence. Earlier, this honorable court directed, my lords, by the impugned order, my lords, assistant commissioner to take a fresh notice under the provision of law. So earlier order is, my lord, disallowed. I bring notice of this order court.
Clear order is page number?
Lord, at page 30,
Page 30, my lords.
to the notice which has been issued
But
pursuant to the
29 and
no
30.
confidence motion having been moved by the members.
Clear order of this court ಎಲ್ಲಿ?
That is not produced.
Ilide. That's it. Ramana. Bear number, page number 18, my lords. Krishna Kumar.
Yes.
Singh ಇದೆ. Singh. ಯಾವ್ದು ಹೋಗಿದ್ರು ನೋಡಿ ಆರ್ಡರ್ ಕಾಪಿ ತಪ್ಪಾಗಿದೆ. ಎರಡು ಸಾಹೇಬ್ ಕರೆಕ್ಟ್.
In the morning, which I made a submission, same order.
ಇಲ್ಲಿ my question is, my lords, as per in 29 page number. So 49 is not compliant. There is allegations. If it is, there is allegation, my lords, they must take the report from the Taluk Panchayat as per the amendment rule 3(2). 49 ಇದೆ. It is 49, then I have no case, my lords. If there is allegations, my lords,
Again, when it has been issued, 49 has not been followed.
ಹೌದು. ಅಲ್ಲಿ
First time it was not followed.
ಫಸ್ಟ್ ಅಲ್ಲಿ it is defective notice.
ಹಾ.
ಅದ್ರ ಮೇಲೆ ಅದು it is liberty to given by this honorable court. In para number
Gram
30.
Swaraj Act. Separate book ilwa. What according to has not been followed?
So as per the section 49, my lords, if they are made allegations, so then assistant court seek that report from the taluk panchayat officer. My lords. So whether the allegation is or not, that is the case, my lords, as per the judgment held by the division bench and also the single judgment. So as per rule 3(2), my lords.
What, which provision of
My lord,
49?
they
has
are
not been
under
followed?
the 49(2). Now 49(2) has been omitted.
My
Which
lord,
has
research-
not been, what has not been followed?
So my lords, as per the judgment of this honorable courts, in para number 15, my lords. Para number 15.
Is the 15/12/2018
Huh.
order?
Order.
Yes. That was a,
Para number 15, my lords. 15, in the present case, the member moving the motion have not mentioned under which provision they are issuing notice of motion of no confidence. Accordingly, in such case, it would fall to the assistant commissioner to make very cursory inquiry into the content of notice of motion and determine as to whether the said motion of no confidence is one under section 49 without allegation or 49(2) with allegation of the act and proceed. It is clear that if the legislature had intent to, there were two categories of motion of no confidence. The assistant commissioner would only to have decided on the basis of a bare perusal of the complaint as to which category the motion of no confidence would belong to. If it were to be done under section 49(1) of the act, the assistant commissioner has to proceed with the same as per the rule.
where is the notice?
Notice, my lords. That is while page number 49, my lords.
Page number 40?
29.
29. Page number 29. ಪೇಜ್ ನಂಬರ್ 29 ದಲ್ಲಿ ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯದಲ್ಲಿ ಕೆಳಗೆ ಸಹಿ ಮಾಡಿದ ಗಳಿಗೆ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯ ಸದಸ್ಯರಾದ ನಾವು ಮಾನ್ಯರಲ್ಲಿ ವಿನಂತಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ಗಳಿಗೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀಮತಿ ಮಹಾನಂದ ಸಿದ್ದಪ್ಪ ಮೆಲ್ಗೇರಿ ಅವರು ಗಳಿಗೆ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರನ್ನು ವಿಶ್ವಾಸಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳದೆ ಒಟ್ಟು 20 ಸದಸ್ಯರ ಪೈಕಿ ಯಾರು ಗಮನಕ್ಕೆ ತರದೆ ಶಾಸನಬದ್ಧ ಕರ್ತವ್ಯಗಳನ್ನು ಮರೆತು ಗ್ರಾಮ ಪಂಚಾಯತ್ ನಿಯಮಾನುಸಾರ ನಡೆಸಬೇಕಾದ ಗ್ರಾಮ ಸಭೆ, ಸಾಮಾನ್ಯ ಸಭೆ, ಸ್ಥಾಯಿ ಸಮಿತಿಗಳು ನಡೆಸದೆ ದುರಾಡಳಿತ ಮಾಡಿಕೊಂಡು ಹೋಗುತ್ತಿದ್ದು ಕೆಪಿಆರ್ ಕಾಯ್ದೆ ಪ್ರಕಾರ 93(4) ಪ್ರಕರಣ 58 ಗ್ರಾಮ ಅಧ್ಯಕ್ಷರ ಕರ್ತವ್ಯಗಳ ಅಧಿಕಾರವನ್ನು ದುರುಪಯೋಗಕೊಂಡಿರುತ್ತಾರೆ ಅಂತ ಅಲಿಗೇಷನ್ಸ್.
ಆಮೇಲೆ ಮುಂದೆ ಓದಿ.
ಇದರಿಂದ ಸಾರ್ವಜನಿಕ ಶಾಸನಬದ್ಧ ಆಶಯಗಳಿಗೆ ಹಾಗೂ ಗ್ರಾಮಗಳ ಅಭಿವೃದ್ಧಿಗೆ ಸಂಪೂರ್ಣ ಧಕ್ಕೆಯಾಗಿದ್ದು ಇವರ ಮೇಲೆ ಕರ್ನಾಟಕ ಗ್ರಾಮ ಸ್ವರಾಜ್ಯ ಮತ್ತು ಪಂಚಾಯತ್ ರಾಜ್ ಅಧಿನಿಯಮ 1993 ಪ್ರಕರಣ 49 ಕಲಘಟಗಿ ತಾಲೂಕು ಗಳಿಗೆ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ಅವಿಶ್ವಾಸ
49 ಮೆನ್ಷನ್ ಆಗಿದೆ.
49 ಮೆನ್ಷನ್ ಆಗಿದೆ. But it is, my lords, as per that, I have taken all the Sabha notice as per the, I have produced the document also.
Notice agreed, you have to reply.
That is rule 3 subclause 2, I am saying. As per the Panchayat amendment, rule 3.
You are relying on a judgment which was passed in respect of a situation where 49(2) was in existence.
Yes.
The 49(2) has been deleted.
With effect from 2020.
2016.
20.
But here, my lords, as per the, my lords, recent amendment by on 4/10/2018, rule 3, my lords, Grama.
It has been effective
Karnataka
from
Grama
31/3/2020.
motion.
31(3).
2020.
ಇಲ್ಲಿ omitted on 31/3/2020. Prior to ಅದು 16 ಅಲ್ಲಿ
Yes,
ಬಂದಿದೆ.
yes.
16 ಅಲ್ಲಿ ಬಂತು, 20 ಅಲ್ಲಿ ಹೋಯ್ತು.
ಹೌದು.
16 ಅಲ್ಲಿ ಬಂದಿದ್ದಕ್ಕೆ 18 ಅಲ್ಲಿ ಆ ಜಜ್ಮೆಂಟ್ ಬಂತು.
ಹೌದು.
20 ಅಲ್ಲಿ ಹೋದ್ಮೇಲೆ ಆ ಜಜ್ಮೆಂಟ್ won't
Next ಇದೆ amendment rule 3, my lord, 3(2).
Rule 3.
ಅದು page number as per manual, my lord, page number 1296.
1296.
In the same.
96A. ಅದು ಬೇರೆ ಇರ್ಬೋದು. ಕರ್ನಾಟಕ ಗ್ರಾಮ ಸ್ವರಾಜ್ಯ ಪಂಚಾಯತ್ ರಾಜ್ ಮೋಷನ್ ಆಫ್ ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ಅಧ್ಯಕ್ಷ or ಉಪಾಧ್ಯಕ್ಷ ಆಫ್ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಮೆಂಡ್ಮೆಂಟ್ ರೂಲ್ 2018.
Rule 3.
Rule 3, subclause 2, my lords. Amendment of Rule 3. Amendment of Rule 3.
Yes.
In principal rule, my lords, in subclause 2 ದಲ್ಲಿ, in sub-rule 2, after the words shall give to the member, the word, the assistant commissioner shall make sure that allegation are specific in the attached list of notice to prepare a report within 7 days in respect of the, my lords, Taluk Panchayat Executive Officer. If they made allegation under section 49(2) subclause, my lords, then, my lord, assistant commissioner sought a report from the Taluk Panchayat officer.
That 49(2) no longer exists.
But sir, as per the, my lord's amendment.
49(2) ಇದ್ರೆ ಇದು ಬೇಕು. 2016 ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ ನೀವು 2020 ಅಲ್ಲಿ ಇದು ಫರ್ದರ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ.
It is only if there is allegation under subsection 2 of section 49. If there is no allegation, it can be moved with allegation, without allegation.
Yes.
Here with allegations, my lords.
Even then,
14.
for cause, without cause. Your 49 provides for moving of a no confidence motion without cause, without reasons.
Please.
Reasons ಬೇಕು ಅಂತ ಏನಿಲ್ಲ.
ಅಲ್ಲ, ಅದು ಕರೆಕ್ಟ್. ರೀಸನ್ ಇಲ್ಲ ಅಂದ್ರೆ then I have no case.
ಇವಾಗ 49(2) ಓದ್ಮೇಲೆ
ರಿಪೋರ್ಟ್
ರಿಪೋರ್ಟ್ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. But as per the direction, they have not, as per direction issued by this honorable court.
Direction issued is in accordance with law ಅಂತ.
But as per the,
You
my
can't
lords-
argue on a non-existent provision.
Yes, yes, yes.
ಇದ್ದಿದ್ದವಾಗ 20 ಅಲ್ಲಿ ಒಳಗ್ ಬಂದಿದ್ರೆ 4 ವರ್ಷದ ಹಿಂದೆ 5 ವರ್ಷದ ಹಿಂದೆ we could have considered. ಇವತ್ತು ಕನ್ಸಿಡರ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
And another thing is, my lords, as per the provision, section 49. So as per that provision, my lords, 49, they have to enclose the copy of the resolution. So that has not enclosed, my lords. Provision 1 is, my lords, 49(1). Every Adhyaksha or Upadhyaksha of Gram Panchayat shall forthwith deemed to have vacated his office if a resolution expressing want of confidence in him is passed by a majority of not less than not less than 2/3 of the total number of members of the Gram Panchayat at a meeting specially convened for the purpose of this one.
Yes.
So that was not, a resolution is not enclosed.
Meeting is to be convened ಅಲ್ಲ.
ಹೌದು.
That was convened, but that resolution copy is not enclosed, my lords.
Resolution is after the meeting, not before the meeting. This is to call for the meeting, notice to call for the meeting.
Yes, yes, it is.
So once meeting happens, there may be a resolution passed expressing no confidence against you, or if you prevail upon them, they may express confidence in you. That is left to you.
Yes, yes, my lords.
Today it is only calling for the meeting.
Yes,
It's a
it is for
requisition
meeting.
for the meeting.
Yes, yes.
ಇನ್ನ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಬೇಕು.
ಅಲ್ಲ, ಡೇಟ್ ಫೀಸ್
ಇದಾದ್ಮೇಲೆ ಎಲ್ಲಾದ್ಮೇಲೆ
ಅಲ್ಲೇ
ಆಯ್ತಾ?
ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ.
ಎಲ್ಲಾದ್ಮೇಲೆ ಮಾಡಿದಾರಲ್ಲ, ಫಾರ್ಮ್ 2 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದೇ ದಿನ ಮಾಡ್ತಾರೆ.
18/125.
ಎಸ್ ಮಾಮ್.
ಅದೇ ದಿನ ಮಾಡ್ತಾರೆ.
ಅದೇ ದಿನ ಅವಾಗ ರೆಸಲ್ಯೂಷನ್ ಮಾಡ್ತಾರೆ. ಡಿಪೆಂಡಿಂಗ್ ಆನ್ ವಾಟ್ ಯು ಡೂ. ಸೊ ಯು ಆರ್ ಪುಟ್ ಆನ್ ನೋಟಿಸ್. ಏನ್ ಮಾಡ್ತೀರಾ?
Yes, please.
Petitioner
14(2).
Learned AG accepts notice for respond number 1
and 2.
and 2. PDO Kalgatki.
ವಿಡಿಯೋ ಕಾಲ್ಗೆ
ಯಾವ್ದೋ ಒಬ್ಬರು ನೋಟಿಸ್ ಹೋಗುತ್ತೆ, ಹೆಸರು ಹೇಳಿದ್ರೆ. Is also is directed to accept notice for respond number 3. Notice to respond number 4 to 17 is dispensed with in view of the proposed order to be passed. The petitioner is before this court seeking for the following reliefs. Respond number. And the petitioner, here ನೀವು ಅಧ್ಯಕ್ಷನ ಉಪಾಧ್ಯಕ್ಷ?
ಅಧ್ಯಕ್ಷ.
ಅಧ್ಯಕ್ಷ, my lords.
The petitioner claims to be the president stroke Adhyaksha of
ಆಫ್ ಗಳಗಿ ಗ್ರಾಮ ಪಂಚಾಯತ್.
Gram Panchayat.
Galagi Gram Panchayat from Ward 3. Having been elected from Ward 3 thereof. The petitioner is before this court challenging the notice dated 30/12/24 issued by the Assistant Commissioner Dharwad calling for a meeting to consider the requisition made, calling for a meeting on 18/1/2025 at 10:30 a.m. to consider the requisition submitted by respondent number 3 to 17 to move a resolution expressing no confidence with the petitioner's performance as the Adhyaksha. The submission of Sri Karvi Learned Counsel for the petitioner is that in the requisition dated
24/12/2020.
what is the date?
24/12/2024.
Illide.
ಲಾಸ್ಟ್ ಬರ್ದಿದ್ದಾರೆ 24/12.
24/12
ಅದು ಇದರಲ್ಲಿದೆ
4
30 ಪೇಜ್ ನಂಬರ್ 30 ಅಲ್ಲಿದೆ ಗಳಿಗೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸದಸ್ಯರ ಅರ್ಜಿ 24/12/24.
24/12/2024 at annexure L, no reasons based on which the no confidence motion is proposed to be moved, have been mentioned in the requisition. Secondly, he submits as required under subsection 2 of section 49 of the Karnataka Gram Swaraj and Panchayat Raj Act 1993. Secondly, he submits that a copy of the resolution in relation thereto has not been enclosed either along with the requisition or along with the notice, impugned notice dated 13/12/2024. Thus, he submits that both the notice and the requisition is required to be quashed. Shri Kalsur Matlar and AGA would submit that subsection 2 of section 49 has been deleted with effect from 31/3/2020. In this regard, Shri Karvi relies upon a decision of the coordinate bench of this court dated 15/12/2018 in WP 50210 of 2018, more particularly para 15 thereof, 15 and 16 thereof, which are reproduced hereunder for easy reference. By relying on the same, he submits 15, 16, 21. By relying on the above, he submits that whenever any notice, whenever any requisition for a meeting to consider a resolution for no confidence is called for, the details and the basis on which the no confidence is sought for is required to be mentioned. The non-mentioning of it would entail, would result in invalidity of the said notices, entailing this court to take necessary action in relation thereto. Shri V.S. Kalsur Matlar and AGA would submit that subsection 2 of section 49 relied upon by the petitioner has been deleted with effect from 31/3/2020, and therefore the order dated 15/12/2000, order in Purnima Sudinske Supra, which was passed after the introduction of subsection 2 of section 49 on 25/2/2016, before the same was deleted on 31/3/2020, the order having been passed on 15/12/2018 would not be applicable to the present case. Insofar as the second contention, he submits that at present a requisition for a notice for a meeting has been submitted, acting upon which the Assistant Commissioner has called for a meeting on 18/1/2025. It is for the council to decide on that date as to what resolution is to be passed. The question of enclosing a resolution along with the meeting requisition notice would not arise. Heard so and so, the newspapers. The short but important question that would arise for consideration is whether there's a requirement to mention the allegations in a requisition notice issued by the councillors, by members seeking for convening a meeting to consider a no confidence motion. Section 49 of the Panchayat Raj Act is reproduced hereunder for easy reference. Section 49 as on date is reproduced hereunder for easy reference. Prior to 31/3/2020, there was a subsection 2 to section 49, which was available on the statute book, which reads as under. The said subsection 2 had been inserted by Amendment Act number 44 of 2015 with effect from 25/2/2016 and continued on statute book until 31/3/2020, which came to be omitted by Act number 49 of 2020. It is taking into account both subsection 1 and subsection 2 of section 49 that this court in Purnima Sudhin's case, by referring to the judgment of the division bench of this court in Srimati Lakshmama was the state of Karnataka and others, bracket WA number 844 of 2018 and connected matters, held that when a motion for no confidence is moved, it would be the duty of the Assistant Commissioner to make a cursory inquiry into the contents of the notice of motion to determine as to whether the said motion of no confidence is one under subsection 1 of section 49, bracket without allegations, or under subsection 2 of section 49 with allegations. And in furtherance thereof held that the legislature had intended that there were two categories of motions of no confidence. If such a motion was moved under subsection 1 of section 49, the Assistant Commissioner had to proceed with the same as per the rules framed. If the said motion was under subsection 2 of section 49, the Assistant Commissioner would have to ascertain the veracity of the allegations made by a cursory examination. In the present case, as referred to supra, subsection 2 of section 49 has been omitted with effect from 31/3/2020. Thus, as on date, there are no two there is only one category of a motion of no confidence, and as on date, there are no two categories, which was dealt with by in Purnima Sudhin's case and Lakshmama's case. Subsection 1 of section 49 envisages a motion of no confidence being moved without making any allegations. If that be so, there would be no requirement for the notice of motion to contain any allegations. And as such, the aforesaid judgments in Purnima Sudhin's case and Lakshmama's case would not be applicable post the omission of subsection 2 of section 49 with effect from 31/3/2020. If that be so, in view thereof, the contention of Shri Venkatesh Karvi, learned counsel for the petitioner, that there are no allegations which have been made in the notice of motion is not sustainable and is liable to be rejected. ಹಂಗ್ not applicable ಬರಲ್ಲ actually. ದೊಡ್ಡದಾಗಿ not applicable. In that way of the matter, Purnima Sudin and Lakshmama are not applicable ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, ಅದು ನೋಡ್ದಾಕಿ ಅದನ್ನ. The judgments in Purnima Sudin's case and Lakshmama's case categorically made out a distinction between a no confidence motion under subsection 1 of section 49 and that under subsection 2 of section 49. Now that subsection 2 of section 49 has been omitted, the observation made in the said judgments insofar as subsection 1 of section 49 would only be applicable, and the observation made in regard to a notice of motion under subsection 2 of section 49 would have to be eschewed, since the said provision under subsection 2 of section 49 would have to be eschewed, since the said provision no longer exists in the statute book. Even as held by the coordinate bench of this court in Purnima Sudin's case and the division bench of this court in Lakshmama's case, a notice of motion under subsection 1 of section 49 is one without allegation, and no allegations are required to be mentioned in the requisition notice of motion. In that way of the matter, the submission made by Sri Venkatesh Karvi that even a motion under subsection 1 of section 49 requires reasons and allegations is not sustainable. As regards the second contention of Sri Venkatesh Karvi that the resolution has not been enclosed along with the notice of motion, this said submission would be putting the cart before the horse. The notice of motion has been moved to call for a meeting where a resolution is required to be passed. Acting on the said notice of motion, the Assistant Commissioner has called for the meeting on 18/1/2025 at 10:30 a.m. This notice of motion would be considered in the said meeting and resolution passed. A resolution cannot accompany a notice of motion, but is a consequence of a notice of motion being moved and the meeting held. In that view of the matter, the second contention by Sri Venkatesh Karvi also stands rejected. No grounds being made out, the petition stands dismissed. Please. MB Pujar for respond number 3.
3. Respond number 3.
Accepts notice, is directed to accept notice.
55, SC Hiremat.
As per information, records are received, Your Lordship. Records are received.
Received, huh? And AGA submit that the records have been received. Counsel for the petitioner and respondents are permitted to take inspection thereof and get ready to address the arguments. Relist on 22nd January.
Srinand Pachapure.
Here for petitioner, bro.
ಯಾರು ಇಲ್ಲ.
Other side, morning also not.
Though counsel for the petitioner is present and ready to address his argument both in the forenoon session and the afternoon session, none appears for the respondent except the AGA. If none were to appear, in the interest of justice, one more opportunity is granted to the respondents to be represented. If none were to appear for the private respondents on the next date of hearing, the matter would be taken up for consideration on the basis of submission made by counsel for the petitioner. Relist on 23rd January. Please.
61, Ahmad Ali, J. Rahman Shah.
For respond number 2. For respond number 3.
None appears for the petitioner, though called twice, once in the forenoon session, once in the afternoon session. If none were to appear for the petitioner on the next date of hearing, petition would be liable to be dismissed for non-prosecution. Relist on 23rd January.
62, Hanmant Reddy, Saukar.
ಇವರೆಲ್ಲ ಹೋದ್ರು ಬಂದಿದ್ದಾರಲ್ಲ ಏನಿಲ್ಲ ಆದರೆ ಅಪೇರ್ ಆಗಲ್ಲ. Same order, none appears, 23rd.
23rd. Ramachandra Malik.
ಅದು 62 ಅದು.
For the petitioner, my lords. Petitioner in challenging the, my lords, order passed by the Tahsildar, my
The
lords.
ಬಾಗಿ ಏನು ವರ್ಕಿಂಗ್ ಇದೆಯಾ? ಇಲ್ಲಿ ಬಾಗಿ ಎಲ್ಲಿ
VC.
ಬಂದಿದಾರಾ ನೋಡಿದೀರಾ?
He was on VC, my lords.
He was on VC. ಇನ್ನು ಹಾಲಿಡೇ ಅಲ್ಲಿ ಇದ್ದಾರಾ? ಮಿಸ್ಟರ್ ಬಾಗಿ ಇಲ್ಲ, VC ಅಲ್ಲಿ ಇಲ್ಲ. Though counsel for the petitioner is present and ready to address the argument, none appears for respondent number 2. Relist on 23rd January. If none were to appear for respondent number 2 on that date of hearing, the matter would be taken up for consideration on the basis of submission made by the counsel for the petitioner.
Please.
67 Arjun, 68 Chetan Munnoli.
For petitioner. And the purchaser. Your alienation was made much prior to enactment.
Have it on 30th.
30th.
Relist on 30th. ಅದು ಯಾವ ಡೇಟ್ ಕೊಟ್ಟು
30th.
Relist on 30th.
Name of senior may kindly be deleted. Name of senior may kindly be deleted.
Registry direct delete the name of Shri R.M. Kulkarni as that appearing for the petitioner. ಇಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿದೆಯಾ? 3, 6, 1 and 2,
That is correct.
4, 5, 6, 7.
Yes.
EGB ಬ್ಯಾಂಕ್ ಯಾವ್ದಪ್ಪ? ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಇಲ್ವಾ? 30th.
69 Arjun, 70 G.A. Gachinmat.
Yes, Gurudev, how are you? Where's Sangram? ಇನ್ನ ರಜದಲ್ಲಿ ಇದ್ದಾರಾ, ಬಂದಿದ್ದಾರಾ?
ಇದಾರೆ.
Sangram Kulkarni.
ಸ್ಟೇ ಇದೆಯಾ?
Stay.
ಮತ್ತೆ ಏನಾಗಿರ್ಬೇಕು ಇದು?
I have
Dispose
checked.
ಆಗಿರ್ಬೇಕು.
No, my lords, it is still pending.
Sangram
Are you still pending?
It is still pending.
My lord, I am online, my lord. I am for
Yes.
the receipt.
Ready?
Yes, my lord.
Yes, ಹೇಳಿ.
Yes. My lords, the plaintiffs, my lords, are the petitioners. They have filed a suit, my lords, seeking for partition and separate possession, which was partly decreed, my lords, and which was carried in RA number 15 of 1998, my lords, by the plaintiffs petitioners themselves in RA number 59 of 2011. During the pendency of the proceedings, my lords, the respondent number 7, my lords, expired. The respondent number 2 and, my lords, the respondent number 7 expired. So, my lords, both of them, my lords, have not left behind the legal representatives. That view of the matter, my lords, a memo was filed stating that, my lords, since they have not left the representatives, the proceedings must be proceeded ahead. However, the objections were raised, my lords, stating that there is some unregistered will in favor of one Mr. Hanumant Venkappa Tungal, and therefore, my lords, he should be brought on record. And accordingly, my lords, since it was only a memo, my lords, the court said that you are supposed to make a proper application. Then, my lords, I made a proper application stating that, my lords, since there is no legal representative that has been left, my lords, by these respondents, the RA must be proceeded ahead. But, my lords, the trial court rejected the same, my lords, on the count that I am supposed to bring the said person as a legal representative.
Who filed the memo?
My lords, I have filed a memo.
You filed the memo to?
That memo, my lords, would find at page 36.
Order on memo 36.
Yes, my lords.
Where's the memo?
Memo, my lords, and in fact, my lords, there afterwards I filed the IA also, my lords, on the very same ground. That IA, my lords, would find at page 21. Since the
Who is
objections,
Hanumant Venkappa Tungal?
Hanumant Venkappa Tungal, my lords, is not before the court. He says that, my lords, he is the legatee under the will. that objection was raised by the other respondents, and therefore, my lords, they were insisting for us to bring him as a legal representative. My lords, it is at my behest, my lords, that I have filed a memo. I will run the risk, my lords, and they cannot say, my lords, stating that, my lords, I should bring this following person as a legal representative who is a legatee under the unregistered will is what they say. And the two, my lords, they have produced one Xerox copy of the will before the trial court, before the lower appellate court, and say that, my lords, since he is a legatee under the will, I should bring him as a legal representative. So, my lords, I am the dominus letters. So therefore, my lords, if I have filed a memo, my lords, it will be at my risk. So under these circumstances, my lords, they cannot force me, my lords, to bring that person as a legal representative. Indirectly, it amounts to accepting him as accepting the will, or as well as accepting the.
So when the memo was rejected, the court came to conclusion that there's no authenticated document produced.
Yes, yes.
And on orders on IF5?
That is at page number 2040, my lords, 40. And my lords, the reasoning portion will start from page number 42. 42. May I read, my lords? Point 7. Paragraph 7.
Yes.
Please. On hearing the arguments and perusal of the documents on the file, it reveals that being agreed by the judgment and decree passed by the principal senior civil judge Jamkandi in OS number 123 of 1998, dated 22/2/2011, appellants have preferred this appeal. On their earlier occasion, the present applicants have moved IA number 4, seeking to set aside the order of abatement passed against the respondent number 2 and 7, which came to be allowed. Along with the said IA, the applicants have moved one memo on 4/3/2016, seeking deletion of the names of the respondent number 2 and 7, as there are no legal heirs of the deceased respondents. This court has dismissed the said memo for the reasons stated therein. Again, the applicants had moved this application seeking to cause entry in the order sheet, and appeal shall be proceeded at the instance of the applicants against the surviving dependents/respondents.
Yes.
On the contrary, the learned.
Yes, Mr. Sangram. You're on mute, Ansat.
My lord, I am audible, my lord?
Yes, now you are.
Yeah.
Who are you to represent this legatee? If that legatee wants to come on record, he has to file an
Has
application.
to file the application.
You are not holding a brief for him.
Yes, my lord. My lord, I am the father of the legatee because I am respondent number 4. The will is executed in favor of the son of respondent number 4, my lord.
So you get your son to come. Why are you taking his defense? If he comes on record claiming to be a legatee, that will have to be decided in terms of 22 Rule 5.
So with that observation, the writ petition may kindly be disposed of.
Petitioner is before this court seeking for the following reliefs. The petitioners were the plaintiffs in OS number 15 of 1998, filed before the senior civil judge Jamkandi for partition and separate possession, which came to be partly decreed. The petitioners plaintiffs themselves took up the said judgment decree in appeal in RA number 59 of 2011, during the pendency of which respondent number 2 and subsequently respondent number 7 expired. The petitioners had filed a memo on 4/3/2016 contending that there are no legal representatives of the deceased respondent number 2 and 7, and their names may be deleted. The said memo came to be objected by the other respondents, more particularly respondent number 5. Who is the father?
Respondent number 4.
Respondent number 4, contending that there was a will which had been executed in favor of his son, Anumant, bequeathing all her properties. Respondent number 7 had executed a will in favor of his son Anumant on 9/3/2013, bequeathing all her properties, and she had expired on 7/6/2013. The trial court rejected the memo on the ground of lack of documentary evidence. Subsequently, the petitioner filed an application in IA number 5 and Order 22, Rule 2, read with Section 151 of the Code of Civil Procedure, claiming that the right to sue survives against surviving that right to sue does not survive against surviving the right to sue survives against the surviving defendants after the death of respondent number 2 and 7, and the matter is required to be proceeded with. This application came to be rejected by the trial court by the impugned order dated 31/5/2016, taking into account the contention of respondent number 4 that a will had been executed by respondent number 5 before her death, and as such the right to sue does not survive against
Respondent number 7.
Respondent number 7, and as such the right to sue does not survive as against the other respondent, but would survive against the legatee of respondent number 7, who is not a party. Taking into consideration the said objection, the said application came to be rejected. It is challenging the same. The petitioner is before this court. Shri Gurudev Gachinmat, learned counsel for the petitioner, would submit that insofar as the petitioner is concerned, there is no will which has been executed by respondent number 7, and the trial court ought to have taken into consideration this contention of the petitioner and proceeded with the matter instead of dismissing the application filed, there being no claim which had been lodged by anyone, much less the legatee, before the trial court. Shri Sangram Kulkarni, learned counsel, appearing for the respondents. Ellarguna for respondent number 1, 2, 2A to C and 2A to C, 2B, matte 2BC yake. 2A to C R3 and respondent number 3 submit that once it was brought to the notice of the petitioner, who was the appellant in the regular appeal, that there is a will executed by respondent number 7, it was but required for for the petitioner to have filed necessary application to bring the said legatee on record. Without doing so, the matter cannot be proceeded with. Heard so and so peruse papers. The contention of the petitioners who are the appellant in the regular appeal is that there is no will executed in favor of by respondent number 7, and there is no legatee. The contention of the respondent, more particularly respondent number 4 in the regular appeal, that there is a will executed and there's by respondent number 7 prior to her death, and there's a legatee who will survive will survive and succeed to the estate of deceased respondent number 7. These allegations and counter allegations have been made by the parties to the litigation. The alleged legatee has not come forward before the trial court or the first appellate court, before the first appellate court. This assumes importance more so since respondent number 4 before the first appellate court is stated to the father of the legatee, the father being aware of the proceedings and agitating the rights of the son legatee. The legatee has not come forward to be impleaded in the proceedings. Whether there is a will executed or not, whether there is a legatee or not, is a question which would have to be determined only if there is a claim made by such legatee and not on the basis of a claim made by one of the respondents to the proceedings. If at all the legatee were to come forward, then the court would have to adjudicate the right of the legatee in terms of Rule 5 of Order 22 of the Code of Civil Procedure, since the petitioners dispute such a will and the existence of such a legatee. In that view of the matter, I am the considered opinion that the first appellate court ought not to have rejected IA number 5 on the ground that the respondents, more particularly respondent number 4, had alleged that there was a will executed by respondent number 7 prior to her death, and the legatee was required to be brought on record, when the legatee himself had not sought to come on record. In that view of the matter, I pass the following order. Writ petition is allowed. A certiorari is issued. Certiorari, 227. A writ petition is allowed. The order dated 31/5/2016, passed by the Additional District and Session Judge Bagalkot, sitting at Jamkandi, on IA number 5, filed in RA number 59 of 2011, is set aside. Consequently, IA number 5 is allowed. IA 5 ಎಲ್ಲಿದೆ?
IFI page 21 annexure C, my lords.
It is held that the right to sue survives against the surviving defendants after the death of respondent number 2 and 7, and their share, if any, would devolve on the other respondents, making it part of the appellate proceedings. Needless to say, in the event of, it's however made clear that the allowing of IA 5 would not come in the way of the legatee filing necessary application to bring himself on record as a legal representative of deceased respondent number 7. In the event, if such an application is filed, the same would be required to be dealt with by the first appellate court as per the observations made here and above.
My lords was pleased to express that if he can come on record, my lords, but if he files an application, that has to be decided in the manner known to law.
That's what we are saying. If he were to file, it will not
If he were to
preclude
file,
untested.
yes.
In terms of the observation made here and above, by holding an inquiry under Rule 5 of Order 22 of the Code of Civil Procedure.
Grateful.
Obliged.
71, Anil Kale.
And for the respondent,
Relist on 30th January. Until we pass orders in that constitutional validity, this cannot be taken.
Lord, this is in respect of only, my Lord, the property was transferred by virtue of a will to sister's son.
How will be part of the SCST Act? Parallel.
no, my lords. I am the person has executed a will in my favor. After lapse of many years, my lords, they come before the court of law stating that, my lords, that they are the wife. In one breath, they claim that she is the wife of
Daughter.
the original allottee. In another breath, she claims that she is the daughter of the original allottee. So there is no, the learned deputy commissioner, my lords, has come to the conclusion as to whether she is a daughter or, my lords, wife is not clear. And therefore, my lords, her application for resumption has been
Family
rejected.
issue, how can the proceedings be
Lord,
filed
this
under PDCL Act?
Here, my Lord, this is the property, my Lord, it cannot be transferred. My Lord, transfer defined. It can be, my Lord, by way of testamentary disposal or by, my Lord, partition, it can be transferred. But within the family. Outside the family, my Lord, if it is fast, then it is a transfer.
Outside ಯಾರು ಆಗಿದ್ದಾರೆ?
ಇಲ್ಲ, younger sisters,
Sister son ಅಂತ ಹೇಳ್ತಾರೆ.
sister son,
Daughter is, my Lord, daughters were excluded.
So whether it is exclusion is proper or not, it is in favor of a third party.
Yes, my Lord.
If it is in favor of Kalsurmat, then yes, third party. Daughter's daughter, sister's daughter, in the
Sister's
family, he has chosen to give it to her.
sister's son, my Lord, he has excluded the own daughter. Here, my Lord, within the family.
Challenging the validity of the will.
Will I have not challenged. Will I have not challenged.
If you are not challenging the will,
Will is
in the
made.
family.
Will is made in the year 2005, 2002. My Lord, in 2004, the property transferred in the name of the legatee, my Lord. The
Transfer baralla. It is only the entries are made.
entries made.
Quit.
Yes. Bequeath, he was alive. Grantee by that time he was alive. He has not died, my lord.
He not died.
He had not died. Grantee was alive.
ಏನಪ್ಪ fact so.
He, my lord, the mutation is made in 2005. He dies in 29/2/2008. Death
3
certificate I
years
have produced.
prior to his death.
Yes, my lord.
And you filed the application in 2012. Yes, Gurudev.
Lords, the
Prior to his death, how
mutation,
can you give effect to a will?
mutation entries, my lords, have to be verified, my lords. There is no mutation entry placed on record to show that, my lords, when the entry exactly has taken place.
Ilidiyappa mutation, no?
Other operative portion of the, my lord, assistant
Where
commissioner.
is the mutation?
Lord,
RTC ಅಲ್ಲಿ.
RTC produce ಮಾಡಿಲ್ಲ.
MR extract ಅಲ್ಲಿ.
MR extract not, my lord, operative portion, may I request page 15.
Produce the RTC and
I'll
MR.
produce the RTC.
Counsel for the petitioner seeks for and is granted 10 days time to produce the RTC and the mutation register extract.
Please.
Released on 20th January. Correct. If that is there prior to the death.
I will verify, even I will verify.
72, Prithvi, KS.
Therefore, petition, my lords, challenging the acquisition proceedings, the ground that, my lords, 4-1 notification has been issued on.
Submission, ಇದರಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಅಂತ ತೋರಿಸಿದೆ.
ಇಲ್ಲ.
So ಅದೇ
Registry director print the name of the government advocate as that appearing for the respondents and delete the name of Ms. Veena Hegde as that appearing for R125. File ಇದೆಯಾ?
ಇಲ್ಲ ಅದು ನೋಟಿಫೈ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ನಾವು ಮೋಸ್ಟ್ಲಿ ಅಲ್ಲ ಅದು
Office ಅಲ್ಲಿ
ಇರುತ್ತೆ
ಇದೆಯಾ?
ಫೈಲ್ ಇರುತ್ತೆ ಅದು.
ಇಲ್ಲ ಅಂದ್ರೆ
ಇಲ್ಲ
19 ಇರುತ್ತೆ.
ಐ ವಿಲ್ ಚೆಕ್ ಯುವರ್ ಅಂಡ್
ಇಲ್ಲ ಅಂದ್ರೆ
I will serve, my lords.
and AGA seeks for and is granted 10 days time to get ready and address arguments. Relist on 20th.
ಪ್ಲೀಸ್.
Statement of objection ಏನೋ objections ಇದೆ.
ಅಲ್ಲ
Filed
the only ground on going to the papers in the morning, the only ground is that, my lord, with regarding to the lapse of under section 24(2), since after 4-1 and 6-1 no award is passed, but they have produced the proceedings before the deputy commissioner and wherein there is a reference with regarding to award having been passed.
Correct ಆಗಿ ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ ಸುಮ್ಮನೆ.
ಇಲ್ಲ ಅದು ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡಿದೆ ಅಂತ there is a finding.
ಇದೆಯಾ?
Diary has been passed by
Year
stating that
1995.
this survey number has been dropped from
ಅದಕ್ಕೆ
the.
Dropped.
Please,
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅದನ್ನ. So I'll-
See the papers.
please.
73, Prasad Kumar, Gunki.
Where is the Chaudial?
Mehuliyad.
ಇನ್ನೇನು ಇಲ್ಲ.
ನಿನ್ನೆ ಬಂದಿದ್ದಲ್ಲ. Usually comes to VC.
Mr. Udial,
Because without hearing, so now in view of the transfer, property has been transferred in the authority, in name of the authority. Now they are seeking for resumption of the land under section 10(6) of the ULC Act.
whatever, we'll deal with your merits.
ಅದೇ
If
that
he
for-
doesn't appear, then we'll have to proceed.
ಅಲ್ಲ
ಒಂದು opportunity ಕೊಡ್ಬೇಕು.
ಅವ್ರು ಬೇಕಲ್ಲ.
Today also none appears for respondent number 4. When the matter was taken up yesterday, also there was no representation. In order to give one more opportunity to respondent number 4 to be represented, relist on 20th January. If there is no representation by respondent number 4 on that date, the matter would be taken up for consideration on the basis of submission made by the counsel for the petitioner.
Please.
Please, madam.
74, Ravi Hegde.
For respondent, my lord.
Labor matter.
Requesting day after tomorrow.
Registry is directed to place the matter before the appropriate roster bench. Labor, ಏನು disabled ಏನಿಲ್ವಾ?
ಇಲ್ಲ. Labor is before this court.
Labor and service ಅಲ್ಲಪ್ಪ.
Labor.
Labor and service ನಮ್ಮ ಮುಂದೆ ಇಲ್ಲ.
75, KS Patil.
ಇಲ್ಲಾದ್ರೂ ಒಳ್ಳೇದಾಯ್ತು. ಅವರೇ ಹಿಯರ್ ಮಾಡಿದ್ದು. ಅವ್ರು ಹಿಯರ್ ಮಾಡಿ it was posted for dictation. For some reason it was again released.
ಇನ್ನೂ ಒಂದ್ಸತಿ ಆರ್ಗ್ಯುಮೆಂಟ್.
We have given judgments also.
ಹಿಯರಿಂಗ್ ಆಗಿದೆ, ಯಾರು ನಾಪ್ಕ ಇರತ್ತೀವಿ. ಇನ್ನೊಂದ್ಸತಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
ಅಲ್ಲ.
Post.
75. Patil.
Appear for the petitioner, my lords. 75.1 and .2 may be taken up, my lords, first. And 75, my lords, it is consequent to those two matters.
Land acquisition, idu KLR.
My lords, the issue involved is,
Ready?
Yes.
my lords,
75.1 ತಗೊಂಡ್ಬೇಕಾ 2 ತಗೊಂಡ್ಬೇಕಾ?
point
One
one,
and 2 are same.
same, 1 and 2 are same.
ಫೈಲ್ ಯಾವ್ದು ತಗೊಂಡ್ಬೇಕು ಹೇಳಿ.
One ತಗೊಳ್ಳಿ.
ನೀವು ಯಾವ್ದೋ ಪೇಜ್ ನಂಬರ್ ಹೇಳಿದ್ರೆ ಇಲ್ಲಿ ಸಿಗಲ್ಲ.
Page number 25, my lords.
Yes.
My lords passed the judgment
Hmm.
on the earlier occasion. This is third round of litigation.
Hmm.
The petitioners and other similar persons were rehabilitated in the year 1960 to a deforested land. Lords, proper procedures were followed.
Yes.
Now,
What happened after this?
after this, my lords, they passed Annexure A, page number 16. And my lords, at page number 18, my lords can find the certain of the plots were granted to us, which were, my lords, does not even bear the survey number. They were shown by some color. There is no access road. They form a gorge. And some of the plots, my lords, were actually on the earlier occasion granted to other people who are in occupation of those lands.
Hmm.
So, the passing of this impugned order is, my lords, in a nature of punishment to the petitioners for approaching the honorable court and seeking directions. This is unfit for human habitation.
Where are the photographs?
Photographs, my lords, this is the
Photographs are not produced.
ಯಾವ್ದ್ರಲ್ಲೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ, ಯಾವುದು ಮಾಡಿಲ್ಲ ಇದ್ರಲ್ಲಿ ಮಾಡಿ.
produce ಮಾಡಿಲ್ಲ.
ಕೊಡಿ ನೋಡೋಣ.
ಮಾಡಿಲ್ಲ. You are ಮಾಡಿಲ್ಲ. Right now.
ಇದೆಯಾ?
ಇಲ್ಲ.
ನಿಮ್ಮ ಹತ್ರನೂ ಇಲ್ಲ?
ಇಲ್ಲ, ಇಲ್ಲ.
ಮತ್ತೆ ನೀವು ಅಷ್ಟೆಲ್ಲ ಹೇಳ್ಬಿಟ್ರೆ ನೀವ್ ಹೆಂಗ್ ಹೇಳ್ತಾ ಇದ್ದೀರಿ? ನೀವು ಹೋಗಿದ್ರ?
I will collect. Now, this is the first issue, my lords. And in this case, plots are partially within the deforested land and partially, my lords, in the forested land. Second set is, my lords, they are totally into the forested land. And later, the first matter, my lords, in respect of first matter, these, my lords, where we were earlier, my lords, inhabiting, it came to be acquired for the National Highway project. And, my lords, in the National Highway project, we are granted, my lords, ex gratia payment. Which, that is, my lords, first petition where we challenged that, my lords, the dispute itself is pending. We were actually residing there. And after this landslide, my lords, which occurred in Karwar district, this plot, my lords, it is opposite to the place where, my lords, landslide has occurred. In about
If the allegations that the allotted land is not fit for human habitation and is a gorge is established, then
Lord, that is,
in order
That
could be
is-
passed would be a issue.
Lord, if
and even the Tahsildar also submits the same report to the Deputy Commissioner.
We can appoint a DLR as a commissioner to verify where the
yes,
location is.
yes.
ನೀವು ಕೇಳಿದ್ರೂ ಅವ್ರು ಏನು ಕೊಡಲ್ಲ.
ಇಲ್ಲ, ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಅಂದ್ರೆ ದೇವ್ರು. ಎಸ್.
This court, vide order dated 13th August 2020 in WP number 116678-116679 of 2019, had directed the respondents, respondent number 2 therein, that is the Deputy Commissioner Uttara Kannada, to consider the representation dated 2011-2019 submitted by the petitioner and to allot an alternative plot similar to that of plot number 37 and 38, which had earlier been allotted to them within the 5 acres of deforested area. In pursuance thereof, it is submitted that the order dated 12/11/2020 has been passed, wherein 2 properties have been identified and made available, allotted to the petitioners. However, Shri K.S. Patil and counsel appearing for the petitioner would submit that the plots which have now been demarcated are unfit for human habitation and have no access. In that view of the matter, I am of the considered opinion that the actual ground reality would have to be ascertained. As such, the jurisdictional ADLR is directed to carry out a survey of the property detailed out in Annexure A to the petition, prepare a sketch of the said properties, demarcating the boundaries thereof, and also to submit as regards the nature of the land, whether there is any access available to the said land, whether the land is a level land or not, and lastly, whether the said land is habitable or not. The AGA is directed to bring the above order to the jurisdiction, notice of the above order to the jurisdiction ADLR, who is directed to carry out the said survey commencing from 16th January 2025, commencing from 10:30 a.m. on 16th January 2025, and submit a report by 24th January 2025, relist on 30th January 2025. Since the order is passed in the presence of both the counsel, the petitioner and or the official respondents would be entitled to participate in the said survey. In the event of there would be no requirement for issuance of any further notice by the ADLR to any of them.
Please.
In the event of either the petitioner or the respondents not participating in the said survey, they would not be entitled to claim any equities.
My lords, plot number changes. Plot number 1, 13 and 36.
A to WP 102503 of 2021 and Annexure A to WP 102506 of 2021. ಮೇಲೆ ಒಟ್ಟಿಗೆ ಹಾಕ್ಬಿಡಿ. ಆಗ್ಲೇ Annexure A ಅಂತ ಹೇಳಿದೀವಲ್ಲ. Annexure A in WP 503 506. ರವಿ ಪಾಟೀಲ್ ರವಿ ನಮ್ಗೆ ಇದೆಯಂತಪ್ಪ
ಇಲ್ಲ ಪ್ಲೀಸ್
ಶೋರ
ಎಸ್
ಸರ್ವಿಸ್
matters
ಹೋಗತ್ತಲ್ಲ ಯಾವಾಗ್ಲೂ ನಂಗೆ ಲಿಸ್ಟು ಕೊಟ್ಟಿಲ್ಲ ಲೇಬರ್ ಮ್ಯಾಟರ್ಸ್ ಓಕೆ ಎಷ್ಟೊಂದಿದಾವೆ ಲೇಬರ್ ನಮ್ದಿಲ್ಲ ಅನ್ಕೊಂಡಿದ್ವಿ
not assigned to portal number
6.
ನಾರ್ಮಲಿ ಸರ್ವಿಸ್ ಅಂಡ್ ಲೇಬರ್ ಒಟ್ಟಿಗೆ ಹೋಗತ್ತಲ್ಲ
normally.
This time, Lord.
ಇದು ಓಕೆ ಯಾವ್ದು ಸೇಲ್ ನಂಬರ್ ಅದು
74.
74. Yes, Mr. Mardi.
Singaraj Mardi.
I will inform.
74 relist on 20th January.
Please.
76 Vittal Teli.
Petitioner is the plaintiff.
Yes, Mr. Teli.
The petitioner is the plaintiff. Filed a suit for specific performance. Notes, defendant number 3 was a subsequent purchaser. My lords, he was got implemented.
They are appearing only for respondent number 1.
Please. He is the only contesting.
And 2 to 4 is dispensed with because they are co-respondents. Yes.
Lords, petitioner is the plaintiff number 1. My lords, filed a suit for specific performance. My lords, as lords,
Plaintiff number 1, respondent number 1. Others are defendant number 2, respondent number.
One of the plaintiff was not available for signature. I had read him as a plaintiff number 2. That respondent number 4.
Respondent number
4.
4.
Please.
But 2 and 3 are defendants, alva?
My lords, but application is only against my lords, the contesting respondent number.
In application under?
For my lords, application for order 39 rule 1 and 2, not to put up a construction.
Injunction only against defendant number 3.
Please, my lords, only against defendant number 3.
Not against the others.
No, not against.
Why are the others arrayed as parties?
Lords, office will raise objections. We are read. I got it dispensed.
ಅಲ್ಲ ಅಲ್ಲಿ suit ಅಲ್ಲಿ ಯಾಕೆ ಮಾಡಿದ್ರಿ?
Lords, defendant number 1 is the owner. Defendant number 2 is a GP holder. Defendant number 3 is a purchaser, subsequent purchaser. First is mine agreement in a suit.
Defendant number 1 ಇಲ್ಲಿ.
Lords, sorry, lords, that there is a correction. That is the respondent number 2 is the defendant number.
array of parties ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ ತಿಳಿ.
That is true. Lords.
There seems to be a lot of
That defendant number 1, that is there is a mistake, my lords.
trial. First appellate court ಅಲ್ಲಿ respondents there is no problem.
No.
Trial court ಹೋದಾಗ ಇಲ್ಲಿ ಸ್ವಲ್ಪ ಸರಿ ಇಲ್ಲ ಇದು.
That mistake. Please.
You are plaintiff number 1.
Please.
Respondent number 4 is plaintiff number 2.
Please. Petitioner number, respondent number 1 is a defendant number 3. The respondent number 2 is a defendant number 1.
Respondent number 2 is defendant number 1.
1 minutes.
And respondent number 3 is defendant number 2.
Minutes.
Defendant number 1 was the owner.
Owner. 2 is the GP holder. 3 is my lords, a subsequent purchaser.
Who sold it to defendant number 3 is represented by a power of attorney holder ಅಂತೀರಾ ಮತ್ತೆ ಅಲ್ಲಿ.
Yes, as per trial court notes that.
Correct?
ಇಲ್ಲ, I am independently contesting, my lord.
No, by GP holder as before applied.
Independently contesting.
Yes, that is what he alleges.
But defendant number, respondent number 2 herein was your vendor.
Please.
To respondent number 3.
2 is his vendor.
Lord.
2 is your vendor.
Yes.
sold the property through defendant number 3.
No, my lords, directly has sold to me. To me, it is through a GP holder.
Both
Agreement
of your
of-
claim. ಹೇಳಿ ನಾವು ಕೇಳಕ್ ಬಂದ್ ನೀವ್ ಹೇಳಿ first. In facts ಹೇಳಿ.
My lords, facts is, my lords, the respondent number one, my lords, the defendant number one, that is the respondent number two is the owner. Respondent number three is a GP holder. He executed, my lords, agreement of sale in my favor on 28/8/2009. Lords, subsequently, my lords, there was a condition on 9/5/2012. Parties decided to execute a sale deed, but defendant number one and two did not come. Lords, sale deed could not be executed. Thereafter, my lords, on 14/5/2012, only within 5 days, my lords, sale deed was executed in favor of the present respondent number n. I filed a suit on 23/5/2012. Lords, it was not within my knowledge, my lords, execution of sale deed in favor of a defendant number 3. I filed a suit. In the suit, my lords, defendant number 1 and 2 took a contention, property is sold. Lords, respondent number 1 herein got impleaded. I made an application, he was impleaded. And my lords, during the pendency of suit, when the matter was set down for an evidence of a defendant, he started to put up a construction. Then I filed application not to put up a construction. That application came to be filed, my lords, on 13/12/2020. Lords, thereafter, my lords, on 15/12/2020, my lords, the respondent number 1 filed objection. Lords, on 2/3/2020, trial court granted a temporary injunction not to put up a construction. Lords, thereafter, my lords, respondent number 1 herein preferred appeal. Lords, appeal came to be allowed, my lords, on 30/10/2024. Lords, thereafter, my lords, trial court itself, I filed a subsequent application to stay there. Notes to stay or direct the respondent number 1 here in not to put up a construction till completion of appeal period. Notes, first appellate court granted, directed him not to put up a construction. Before this honorable court, that interim order has been extended till date. Only my respectful submission, lower appellate court reverses the order of a trial court on the ground that, my lords, his sale deed is higher in valuation. So far as a pecuniary jurisdiction, it holds civil judge junior division has no jurisdiction to entertain the suit itself. On that point, my lords, and one more point which has considered in earlier proceedings, my lords, where the respondent.
What are you challenging here? You are challenging the interlocutory order in the first appellate court.
Please, lords.
The suit is still pending, alva?
Suit is still pending.
They will hold that higher consideration at stage of considering the injunction application.
Please. Lords, while pending, lords, application was filed, that application came to be allowed.
If you succeed in the suit, you won't claim equities.
Yes, my lord. In fact, half of the property it is already constructed.
You will get it free of cost.
To that effect, my friend may, my lords, undertake that.
I will not claim any equity, my lord. If my lord wants an affidavit, I will file an affidavit.
The above petition has been filed challenging the refusal of an injunction order.
But anyhow, my lords, I had an interim till date today, I had temporary injunction.
Refusal of injunction order, whereunder injunction restraining respondent number 1 from putting up construction was sought for. Srivastava Igdale and counsel for respondent number 1 submit that respondent number 1 would not claim any equities, and any construction put up by respondent number 1 would be subject to the result of the suit for specific performance filed by the petitioner in OS number 1013 of 2012, pending on the file of
First Additional Civil Judge and JMFC.
First Additional Civil Judge and JMFC, Belgavi. He is directed to file affidavit of respondent number 1 in that regard, released on 20th January.
'77, Dayanand Bandi.
Hearing for the respondents.
R2 and 3 notice dispensed with.
I'm appearing for respondent 1A to C, my lords.
1A to C. 2 and 3 dispensed with. Yeah.
2 and 3 my sisters, my lords, petitioner sisters.
Yes.
They are co-owners.
LR mat.
My lords, this is the order challenging the order of the land tribunal on a ground that, my lord, this order admittedly passed without holding any inquiry, admittedly without the notice, and it is passed against a dead person, kept in dark for 30 years, doesn't see the day of a light of the day. And my lords, the circumstances show that it is purely a concocted order. My lords, the genesis of the dispute starts in 2009. In 2009, my lord, these respondents claiming to be a tenants of a particular land, my land is, my lord, survey number 29. My lord, they file a suit against me. That is my father and my father's brother. In the year 2009, that is a suit for injunction, saying that we are interfering in the peaceful possession of that particular land. The allegations in the plaint are that, my lords, their father, that is respondent number 1A to 1C, their father Mallappa Kittur, had filed a form number 7 in respect of 3 lands, survey number 29, 715 and 500 and odd. So he contends in the suit that in respect of 2 lands, the land tribunal has passed the order granting him a tenancy. And in respect of this land, no order has been passed. So in the year 1984, his father files a representation to the land tribunal saying that no order has been passed in respect of survey number 29. Kindly pass the order. That was the representation.
Date of events ಅಲ್ಲಿ ಏನ್ ಸರಿಯಾಗಿ ಇಲ್ವಲ್ಲ.
My lords,
Date of events ಅಲ್ಲಿ ಬರೀ 2 ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ. Synopsis of dates and events ಅಲ್ಲಿ.
It came as a no objection, my lords.
ಇಷ್ಟೆಲ್ಲ ಡೇಟ್ ಹೇಳ್ತಾರೆ ಇರ್ಲಿ.
ಇಲ್ಲ ಅದನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
You make one thing, if so many facts are there, make a.
Illa, very short point, my lords, very short point. So they themselves produce a representation that in the year 1984, his father given a representation to the land tribunal saying that in respect of other 2 lands, tenancy, occupancy rights has been granted, and in respect of only in respect of this land, no order has been passed. So, my lords, they are in occupation of the land, so the injunction is to be granted. That is their suit, my lords. My lord, they have filed a suit against a dead person saying that he is interfering with peaceful possession. So immediately, my lord, as the notice, it is reported to the court that he is dead, my lord. They have brought the legal representatives of this petitioner number 2 on record. So we filed a written statement. So, my lord, the first I was under 39 rule 1 and 2, which they have filed. So they have argued. They have argued on that.
Pandit, this is a LR matter.
Yes.
Whatever suit has happened, what you are challenging is the order dated 14 to 79.
Yes, my lords. For the first time, they produced that particular order in a civil suit. What they say that even in the year 1940, even in the no order has been passed for survey number 29. In 84, his father himself gives a representation. It is their case that no order has been passed. Kindly pass the order. Suddenly, in the year 2009, they produced the certain documents saying that no, in the year 1979 only, the order has been passed in our favor. Immediately, we inquired into the land tribunal. Then we come to know that, my lord, the no notice has been served. At annexure H, my lord, your lordship may kindly see at page number 35.
Records ಬಂದಿದೆಯಾ?
ಬಂದಿದೆ. Last time ಮನೆ ಬಂದಿದೆ. ಗವರ್ಮೆಂಟ್
ಲ್ಯಾಂಡ್ ಟ್ರೈಬ್ಯುನಲ್ ಇಲ್ಲಿರುತ್ತೆ, ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್
ಇಲ್ಲ ಗವರ್ಮೆಂಟ್ ಇದೆ. ಇಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಅದನ್ನ ನಾನೇನೆ ನೋಡಿ ಇದನ್ನ ಸ್ಟಾಂಪ್ ಎಲ್ಲ ಮಾಡಿದ್ದೀನಿ.
We have also perused the records.
ತರ್ಸಕ್ಕಾಗತ್ತಾ ಇವಾಗ?
So I have produced a copy, my lords. Later on, it can be verified.
Pass over by the time the records will come. Pass over.
Isn't Banka engaged?
ವಾಪಸ್ ಕಳಿಸಿದ್ದೀರಾ?
My lord.
ಅಲ್ಲ ಇವಾಗ ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ ಇಲ್ಲ ಡೇಟ್ ಕೊಡೋಣ? Learned AGA seeks for 2 days time to verify if the records are still available with him. Released on 9th January. But both of you have taken inspection.
Yes, my lord.
Of the records you have taken.
We have perused the records.
So it had come.
Yes, my lord.
Whether it has gone back or not.
No, my lord, that is observed in the audit sheet. April ಅಲ್ಲಿ it is observed. Records were there. It was there.
ಐದು ಇನ್ಸ್ಪೆಕ್ಷನ್ ಕೊಟ್ಟೆ, ವಾಪಸ್ ಕಳಿಸ್ಬಿಡೋಣ ಅಂತ. ಇದ್ರೆ ನೋಡಿ, ಇದ್ರೆ we can take it up on 9th, otherwise we'll have to again call for. The existence of the order is in dispute. We'll have it day after tomorrow. You can.
Please.
78.
ಎಲ್ಲಿ ಕೆಳಗಡೆ ಇರತ್ತ ಅದು? You wait, if it comes, we'll take it.
Yes, please.
78.
Pray for a time, my lord.
The request of counsel for the petition released on 30th January.
79, V. Chidanand.
It is made clear that no further adjournment, SCST, 30th January. 79. Yes, Mr. Chidanand. Sangram?
Yes, my lord, I am there.
Next week ಇಲ್ಲ ಸ್ವಲ್ಪ
ಅವಾಗ್ಲಿಂದ ಇಲ್ಲೇ ಕೂತಿದ್ದೀರಾ
ಕೂತಿದ್ರಿ
ಭೇಟಿ ಆಗ್ತಾ ಇದ್ದೀರಾ?
ಅದು ಸೆಕೆಂಡ್ ಕೋರ್ಟ್ ಹೋಗಿ ಬಂದೆ ಸ್ವಲ್ಪ ಇದಾಗಿತ್ತು.
Sangram, you are ready?
My lord, I have appeared on behalf of respondent, legal aids of respondent number 7. I need to file statement of objections in this matter, my lord.
When will you file? In another 10 years?
My lord, recently I have appeared a week's time, my lord. A week's time may kindly be.
2010 matter appa ivaga appear ಆಗಿದ್ದೀರಾ?
ಹೌದು, recently respondent number 7 is dead and I have filed a wakalat on that.
7 did not file any objections during his lifetime.
No, my lord.
7 file ಮಾಡಿಲ್ಲ. Counsel for respondent number 7 A and B seeks for and is granted 10 days time to file a statement of objection. Objections, if any, by 24th January, to be filed by 24th January after service thereof on the counsel for the petitioner, who is granted a week's time thereafter to go through the same and make a submission. Released on 30th January.
Obliged.
Pass over matter. 23.
ಇಲ್ಲ 5 ಇಲ್ಲ.
Lord, in serial number 77.
ಒಂದು ನಿಮಿಷ. 23, none appears for the petitioner. ಯಾರು ಪ್ರವೀಣ್ ಕುಮಾರ್ ಕುಲಕರ್ಣಿ ಬರ್ತಾರೆ? 3 ಸತಿ ಕರೆನ ಬಂತು. None appears for the petition though called thrice. A week's time is granted to the petitioner to comply with the office objection. Released on 20th January.
77.
Yes, Culture 77 ಏನು?
In this, on the earlier occasion, I made a submission that I have secured the records.
ಇದೆಯಾ?
ಇದೆ.
ಅಲ್ಲ ಬಂದಿತ್ತು ಅಂದ್ರು ಮತ್ತೆ ವಾಪಸ್ ಕಳ್ಸಿದ್ವು ಇದೆಯೋ ಅಂದ್ರು ಇವಾಗ ಕಣ್ಣೂರವರು.
ಅಲ್ಲ ಅದು ಮೋಸ್ಟ್ಲಿ ಯಾಕಂದ್ರೆ ಇದು ಬೇರೆ ರೇಪೇರ್ ಹಾಕಿದ್ದಾರೆ ವಾಪಸ್ ಅನ್ಲೆಸ್ ಅಂಡ್ ಅಂಟಿಲ್ ಮೇಲೆ ನೋಡಿ ಡಿಸ್ಪೋಸಲ್ ಆಗಮಟ ವಿ ವಿಲ್ ನಾಟ್ ಸೆಂಡ್ ಎನಿ ರೆಕಾರ್ಡ್ಸ್.
ಎಲ್ಲ ಇಟ್ಕೊಂಡು.
ಹೌದು.
Then produce it.
Yes.
ಎಷ್ಟೊತ್ತಾಗತ್ತೆ ಬರೋದು?
Senior has gone.
ಇದೆ.
Well, I have produced those documents along with my writ petition. It can be verified later on.
We'll have to see the original to find out if ನೀವು ಕನ್ಕಾಕ್ಟೆಡ್ ಅಂತ ಇದ್ದೀರಲ್ಲ.
ಹೌದು ನಂದು ಕೇಸೇ ಅದಿದೆ. ಯಾಕಂದ್ರೆ ಯಾವತ್ತು ಅದನ್ನ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ ಅವತ್ತು ಇನ್ನೊಂದು ಆರ್ಡರ್ ಪಾಸ್ ಆಗಿದೆ ಅವ್ರದ್ದು ಕನೆಕ್ಟೆಡ್ ಇದರಲ್ಲಿ.
But order copy is there on the file.
Yes, my lords, I have produced also.
If order copy is there on the file, concocted ಹೆಂಗೆ?
ಆರ್ಡರ್ ಶೀಟ್. ಆರ್ಡರ್ ಶೀಟ್ ನಲ್ಲಿ ಆರ್ಡರ್ ಹೇಳ್ತಾರೆ ಈ ಆರ್ಡರ್ 14/9 ನಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಡಿಫರ್ಸ್. ಅವ್ರದ್ದು 3 ಲ್ಯಾಂಡ್ ನಲ್ಲಿ ಇನ್ನೊಂದು ಲ್ಯಾಂಡ್ ಒಂದು ಗ್ರಾಂಟ್ ಆಗಿದೆ. ಅವ್ರು ಹೇಳ್ತಾರೆ June 76 ಗೆ ಅಂತ. June 76 ಸೀಟಿಂಗೇ ಇಲ್ಲ.
ಇದೆಯಾ ಫೈಲು?
Records sir.
And AGA seeks for and is granted 2 days time to verify if the records are still available with his office, and if so, to produce the same. Released on 9th.
Please.